two identical HMOs. Same location, same number of tenants, same rental income. Yet one landlord faces a £25,000 fine and criminal prosecution, while the other sleeps soundly with full legal compliance. The difference? Understanding these 7 legal essentials that I'm about to reveal. The legal side of HMO ownership is where many landlords stumble, often with costly consequences. In 2024 alone, UK councils issued over £8 million in HMO-related fines, with individual penalties reaching up to £30,000 per violation. I'm Ella from Plandome, and after helping hundreds of landlords navigate HMO regulations, I've identified the 7 legal essentials that protect your investment and keep you on the right side of the law. The first and most fundamental legal requirement is proper licensing. Since 2018, mandatory licensing applies to all UK properties with 5 or more unrelated tenants forming 2 or more households, regardless of the number of stories. But here's what trips up many landlords. Additional and selective licensing schemes vary dramatically by council. Some require licenses for HMOs with just 3 tenants in specific zones. Licenses typically last 1 to 5 years and must be renewed before expiry. Operating without a valid license can result in unlimited fines, rent repayment orders, and even criminal prosecution. The second essential is planning permission compliance, often overlooked until it's too late. Converting a family home, C3 use class, to a small HMO, C4 use class, with 3 to 6 unrelated tenants may be possible under permitted development rights. However, many councils have implemented Article 4 directions, removing these rights and requiring full planning permission for any HMO conversion. And for larger HMOs with 7 or more tenants, you'll always need planning permission for sui generis use, regardless of local Article 4 status. Operating without proper planning permission can lead to enforcement action, requiring you to convert the property back to its original use at your own expense. The third essential is fire safety compliance, the most scrutinised aspect during inspections. Licensed HMOs must have interlinked smoke alarms on each floor, heat detectors in kitchens, fire doors with self-closing mechanisms, clear escape routes, fire-resistant structures between rooms. You must also conduct and document a thorough fire risk assessment. Following the Grenfell tragedy, fire safety enforcement has intensified significantly. All fire safety equipment must be regularly tested and certified, with records available for inspection. The fourth essential is compliance with minimum room size standards. Since October 2018, bedrooms in licensed HMOs must meet these minimum requirements: 6.51 square metres for 1 adult, 10.22 square metres for 2 adults, 4.64 square metres for children under 10. These measurements apply to usable floor space only. Areas where the ceiling height is less than 1.5 metres don't count. Rooms below minimum size cannot legally be used as sleeping accommodation, and attempting to do so can result in substantial fines. The fifth essential is meeting amenity standards, ensuring adequate facilities for all tenants. Most councils require 1 bathroom for every 4 to 5 tenants, adequate kitchen facilities, sinks, cooking appliances, food storage, sufficient waste disposal arrangements, appropriate heating in all rooms. These standards vary by council, so always check local requirements before purchasing or converting a property. Inadequate facilities not only risk enforcement action, but also lead to tenant dissatisfaction and higher turnover. The sixth essential is compliance with HMO management regulations, the day-to-day legal requirements for running your property. These regulations require landlords to maintain common areas and shared facilities, ensure gas and electrical safety, provide adequate waste disposal, display manager contact information, conduct regular property inspections. You must keep all safety certificates current, including annual gas safety certificates, electrical installation condition reports, EICR every 5 years. Regular PAT testing for appliances. Organised record keeping is crucial. You may need to produce these documents during inspections or when renewing licenses. The seventh essential is understanding tenant rights and responsibilities in HMOs. HMO tenants have all standard tenant protections plus additional rights regarding safety and facilities. You must protect deposits through an approved scheme and provide prescribed information within 30 days. Right to rent checks are mandatory for all tenants, with penalties of up to £3,000 per illegal tenant. Clear house rules help manage shared living, but must not contradict tenant statutory rights or be discriminatory. Before we wrap up, let's cover the 3 most expensive legal mistakes HMO landlords make. First, assuming that one-size-fits-all compliance works across different council areas. Local requirements vary dramatically. Second, DIY licensing applications without understanding the implications of certain questions. Your answers can trigger additional inspections or requirements. Third, neglecting ongoing compliance after initial licensing. Regular updates to regulations mean yesterday's compliance may not meet today's standards. Navigating HMO legal requirements doesn't have to be overwhelming. With the right guidance, you can ensure full compliance while maximising your investment returns. At Plandome, we specialise in helping landlords secure planning approvals and HMO licensing across the UK. Book your free consultation today by visiting the link below. Our experts will review your specific situation and help you navigate the complex legal landscape of HMO ownership. Don't risk fines, enforcement action, or criminal prosecution. Get expert guidance on planning approvals and HMO licensing. Book your free consultation now.